All right, in this video, we're going to go over what's called the 3 post-trial pleadings. Unfortunately, this will assume that the defendant has been convicted at trial, so what is left for them at the trial court level to overturn the conviction. One is called an arrest of judgment, the other is called a motion for new trial, and the third is the notice of intent for an appeal. An arrest for judgment is literally a petition to the court to set aside the judgment for some type of defect. Most of these are procedural defects dealing with the indictment, how it's charged, or something about the proceeding that quite frankly could have been raised pre-trial in a motion to quash. But there is also a little bit of a catch-all that basically says, look, what you just heard, those facts if taken as true, do not constitute a crime as a matter of law. And then you can ask the judge, they so find that, again, taking all these facts as true, if it doesn't meet a crime, then the judge can set aside the verdict. The second most common way that this gets done is if the jury comes back with a responsive verdict that is illegal, meaning someone's charged with murder and they were convicted of aggravated battery. I don't know, I'm just making it up. It's not listed as a formal responsive verdict, and if no one petitioned the court to have it included as a responsive verdict, and inadvertently was, then that verdict can be set aside, and because of double jeopardy, the person is likely not to be prosecuted again, right? The second type of post-trial motion I want to talk about is a motion for a new trial. Now, this is hard to establish because basically your main ground is like newly discovered evidence that could not have been found through the exercise of due diligence of the defense attorney. And since we're just coming off the heels of the trial, it's like, well, how come we didn't find this before? Sometimes this is a witness who didn't show up or couldn't be served and was only found after the trial. Sometimes this is discovery of exculpatory evidence, i.e. evidence favorable to the defendant that was only discovered after trial. So what happens in a motion for new trial is the defense attorney can present evidence, the newly discovered evidence, and the judge is going to look at whether or not this was able to be discovered before trial. If it was through due diligence, the motion is denied. If it couldn't, then the judge is going to have to assess that, yeah, this would have changed the verdict, okay? And motion for new trial has about 6 or 7 different categories it can fall into. There's a big catch-all in the interest of justice that most defense attorneys will peg their hat on if they don't have any newly discovered evidence to deal with. And the last is the notice of intent to an appeal, okay? This is where you accept the jury's verdict, but you go to challenge it to a higher court. Louisiana has 5 circuit courts of appeal that divide up the 64 parishes, and then after that, you go to the Louisiana Supreme Court. What's important on the appeal is you're not bringing up new evidence outside of a motion for a new trial. You are really just limited to the judge's rulings. Pre-trial rulings on motions to suppress, pre-trial rulings on motions in limine. You're looking at adverse rulings on objections made by either party during the trial, and you're maybe looking for the sufficiency of the evidence. As a general rule, if an objection wasn't noted, either through a written motion that was denied or actually standing up in court and saying, I object, you waive the right to challenge that on an appeal. So an appeal is like, maybe we'll go to a football analogy, like an instant replay. Okay, but you need to have preserved the issue to get to the Court of Appeals. So those are your 3 most common post-trial pleadings.